5 seconds. Start. By holding that filing of false criminal cases would amount to cruelty within the meaning of Section 13 of the Hindu Marriage Act, and on that ground, the husband was entitled to a decree of divorce. Stop. Reliance is also placed by the learned counsel for the appellant on the judgment of Supreme Court submit that filing of a false and frivolous complaint under section 198A itself amounted to cruelty. Stop. It is submitted by the learned counsel for the appellant that in the examination in chief filed by the respondent in the proceedings before the trial court, there were no allegations of dowry made by the respondent against the appellant and his relatives. Stop para. Only during the course of cross examination of the respondent, she alleged demand of dowry for the first time alleged to have been made by the appellant and her family members. Stop. He submits that the allegation made by the respondent about demand of dowry has been totally disbelieved by the criminal court while dismissing the complaint filed by the state of Maharashtra. Stop. The prosecution did not challenge the said findings rendered by the learned joint judicial magistrate first class Karnal. Stop. Learned counsel for the appellant also placed reliance on the unreported judgment of this court delivered on 16th August 2012 in case of Shiv versus Rupali in Family Court Appeal number 118 of 2006 in support of the submission that when the complaint filed under section 498A by the wife is dismissed, the inference can be drawn by the court that the said complaint was a false complaint and filing of such complaint amounted to cruelty within the meaning of section of Hindu Marriage Act. Stop para. Learned counsel appearing for the respondent wife on the other hand relied upon the findings rendered by the two courts below and would submit that the said findings of fact being not perverse cannot be interfered with by this court under section 100 of the Code of Civil Procedure 1908. Stop. He invited my attention to the findings rendered more particularly in paragraphs 23 to 25 of the order passed by the learned trial judge and the issues framed in the said proceedings. Stop. He submits that the appellant had already given up grounds of nullity of the marriage before the lower appellate court. Stop. The trial judge found in favor of the accused by taking note of some discrepancies in the complainant's version Stop.